All right, so let's get started. Congratulations, you've made it to the final recorded lecture for week one, spring 2020, Criminal Law Online with Professor Dennis. I know we've had a few kinks and we're all working them out together. I hope this has been an okay process for you. If it hasn't, if there's any way I can help, whether it's with technology or just comprehension of the material, or just coping with what's going on, please let me know. Send me an email directly or post your concern on Twin, and we'll try and get it taken care of. All right, so for this particular lecture, we're going to talk about non-forcible rape. So I think the last recording I characterized as it was also the topic of non-forcible rape, but otherwise, more particularly, we were dealing with date rape or acquaintance rape. This particular recording really does deal with what is, as a legal matter, considered non-forcible rape. Rape by impersonation, rape by fraud, rape by extortion, rape of intoxicated persons. And as well, in this lecture, we'll talk about statutory rape. Let me just say a little bit about the materials on this particular topic. So you have the handful of assigned pages on non-forcible rape, and then also another handful of pages on statutory rape. You should read those before you listen to this lecture. And then after the lecture, I'll have a number of supplemental materials that you should take a look at with respect to this topic of non-forcible rape. And as well, I have added a little brief section on reform of rape. And there's no assigned reading in your textbook. Instead, I will put onto Twen a short article you should read and then a link to a video you should read. But we'll talk about those at the appropriate time in this recording. Okay, so to begin with this concept of non-forcible rape or beyond forcible rape or other forms of sexual assault, however you want to characterize this small section. Again, as I mentioned, we're looking at the issues of rape by impersonation or fraud, or by extortion or coercion, or rape of unconscious or intoxicated persons. And the case we have in this particular section to consider is the Borough case. So take a look at the first slide. In this particular case, we're dealing with the defendant who impersonated a doctor and convinced the victim to engage in sexual intercourse with an anonymous sperm donor in order to cure a highly infectious disease she had contracted. Wow. In retrospect, as I'm talking about this seems quite a bit too closely related to our current pandemic we're dealing with. But in any event, try and please put that to the side. All right, so the facts of this case are very interesting. We have the defendant who impersonates a doctor, and he convinces a woman to engage in sexual intercourse with an anonymous sperm donor. And his explanation is that she needs to have sex in order to cure a highly infectious disease that she had contracted. Ultimately, the defendant is charged with multiple criminal offenses, including 3 sexual assault crimes and 2 other crimes. As far as I can tell, the trial court dismissed one of the sexual assault charges, a forcible rape charge, count 1, because the defendant did not threaten to kill the victim. Right? So if you recall all of our conversation about traditional forcible rape statutes and more modern forcible rape statutes that might not require proof of physical force. Here, right, the problem for the forcible rape charge is there was no physical force and the defendant did not threaten to kill the victim. Instead, he forecasted or predicted her death from this disease if she did not consent to either a surgical procedure or the sexual intercourse. And we know that she chose the latter, sexual intercourse. Also, the trial court dismissed count 3, and this was with the government's consent. So the remaining issue on appeal concerns count 2, on which the defendant was convicted, and whether it should be dismissed as a matter of law. In its ruling, the court sets out the common law distinction between fraud in fact and fraud in the inducement. So fraud in fact exists where it negates the complainant's consent because what happened is not what was consented to. In other words, the defendant did not consent to sex because what was consented to is not what she expected. So, for example, in the Larry Nassar case involving USA gymnasts and his medical treatment of them, if you're familiar with that case, I'm going to talk a little bit more about it in a moment, right? But he was actually a medical doctor, but he told his patients, these USA gymnasts, that he was performing appropriate medical procedures on them, right? And in fact, it seems that he was sexually abusing them or sexually assaulted them. But they consented to what they thought was appropriately medical contact, all right? But in fact, that was not what was happening. So that would be a scenario involving fraud in fact. And there, the, the consent that the complainants, the USA gymnasts, gave was to the medical procedure, not to inappropriate or unwanted sexual contact. So in those particular cases, fraud in fact has occurred, which negated the complainant's consent. They did not consent to the sexual contact. Contrast fraud in fact with fraud in inducement, which does not negate a complainant's consent because the complainant consented to what actually occurred. The motive for consent might have been based on deception or fraud or impersonation, but in some sense we say the complainant consented to the contact and received or engaged in the contact that was desired. So, for example, in the Boro case, she consented to engage in sexual intercourse, and that is in fact what happened. Now, yes, she engaged in the sexual intercourse because of deception, but that does not negate the consent she gave. And this is the majority approach. And so here the court concludes, as a matter of statutory interpretation, the statute that supports count two, the count two rape charge, will be interpreted in accord with the more majority approach. And so, as a legal matter, count two is also dismissed. All right, so count one, the forcible rape charge, was dismissed because there was no threat of serious bodily harm or a threat on the part of the defendant to kill the victim. Count three was dismissed with the government's consent. And ultimately, as a matter of law, count two is dismissed based on fraud in the inducement. That seems like a highly unreasonable outcome, and I can understand if you are troubled. But of course, as the court reminds in the closing portions of the opinion, even though Boro was not convicted of non-forcible rape, count two, he is likely to be convicted for theft and burglary, the two remaining non-sexually based charges, right? This is your chance to review. We have discussed theft charges and we have discussed burglary charges. So on your own time, as you're reviewing your materials, think about how you could prove, if you're the government, either a theft charge or a burglary charge or both against the defendant. Take a look at the next slide. And here I provide you with a problem that is based on potentially fraud or impersonation, right? And it's designed to capture your understanding of the Boro case and the majority approach that fraud in fact does negate a complainant's consent, whereas fraud in inducement does not negate a complainant's consent. So on your own or with somebody, take a look at this particular problem and let me know your thoughts on twin. So next slide. Here, I just wanted to take a moment to describe some recent notorious cases of late over the last several years. There have been a number of cases in this area of non-forcible rape on the basis of fraud or impersonation or extortion or coercion, or cases involving unconscious individuals. these cases have received lots of media attention and um, made their way into the public consciousness. And so I wanted to put them on your radar and offer an opportunity to answer some questions about them if you like. But so the first is a fraud-based case, which I discussed already a little in the context of Borough, involving USA Gymnastics, right? USA Gymnastics is the national governing body of gymnastics in the United States. And USA Gymnastics faced hundreds of allegations that the organization ignored abuse by coaches, and as well that it ignored abuse, sexual abuse, by Dr. Larry Nassar, who's pictured here in the slide. Dr. Nassar was the team physician for the organization. He worked 4 Olympic Games. He was also on the faculty at Michigan State. And the allegations from um, uh, tens of, maybe even hundreds of young girls was that he sexually assaulted female teenage gymnasts under the guise of treating them medically. So, as I said before, he would tell them that he was engaging in some medically appropriate touching while examining them. And in fact, he was engaging in inappropriate sexual contact with these young girls, some of whom were adults by the time they raised their complaints. He was charged both in um, state court and in federal court with a host of charges based on the number of victims. And ultimately, he was convicted on those charges in the jurisdictions, and he will spend virtually the rest of his life, if not the rest of his life, incarcerated. So another quite well-known case, one that is of more recent vintage, having just literally ended during the course of our semester, is the New York prosecution of Harvey Weinstein. And he's was accused of using his influence as a film producer, who was highly respected for his professional abilities. Um, he allegedly uh, used his status and power to lure women, coerce women into engaging in sexual assault, or or being in positions where he could sexually assault them forcibly. All right, so he was charged with a number of offenses in New York, all on the basis of forcible sexual assault or predatory sexual assault. But the underlying theme, the story the government told, was that he used his influence and power to put himself in a position where he could have access to these women, to then sexually assault them, to forcibly rape them, and then when they protested or made allegations, he would essentially extort or coerce them into silence. Next slide. The next slide here deals with 2 fairly prominent cases of sexual assault of unconscious victims, right? And in particular, that the defendants, um, in the case of Bill Cosby, the defendant in the case of Bill Cosby, provided intoxicating substances to individuals unknowingly. And then once they were inebriated or essentially unable to protest or respond, he would sexually assault them. And of course, if you're familiar with this case, there are many allegations going back decades. Uh, Ultimately, despite investigations in many different jurisdictions, it was only in Pennsylvania that was determined that it was able to prosecute him for these alleged incidences because of the passage of statutes of limitations. And in the first trial, the jury returned a verdict of not guilty. And in the second trial, which occurred in 2018, the jury convicted him. On your right in the slide is a picture of Brock Turner, whom you may or may not be familiar with. This case is a little bit older in comparison to, for example, Bill Cosby's recent trial. So this case involves self-intoxication on the part of the complainant and an unconscious victim, right? So Brock Turner, in short, was a Stanford student, a Stanford swimmer who sexually assaulted an unconscious woman in public. He sexually assaulted her by digitally penetrating her, that is, penetrating her vagina with his finger. And he was stopped in the course of that assault by two men who observed what was happening and tackled him and held him there until law enforcement came. Ultimately, the case is investigated and he is convicted after a jury trial, and the judge sentences him to 6 months incarceration, 3 years probation, a lifetime of sex offender registration, and completion of a sex offender treatment program. So, all of these cases present interesting food for thought, right? Including how do we handle aged or older allegations, right? How do we treat cases in which there are many complaining victims who have raised their stories or tried to raise their stories or report what has happened to them? How do we think about under enforcement or unenforcement of sexual assault? Um, what do we think about prosecutorial discretion in making decisions about which charges to bring for which victims um, and what particular types of charges to bring? And then also the role of intoxicants, right? So if you recall way back in the early semester when we talked about the Utter case, that was the first time we had encountered this question of intoxication. And we learned from that case that voluntary intoxication is not a defense in most jurisdictions. So if a defendant claims I engaged in the behavior because I was intoxicated, that is not a defense. At best, in a small number of jurisdictions, it might be an impartial defense, but on the majority approach is that voluntary intoxication on the part of a defendant is not a defense. Um, but the question becomes, how do we handle here intoxication by the defendant, which is often argued to have affected the individual's judgment and or ability to engage in the conduct or ability to comprehend or obtain consent. And then as well, how do we think about intoxication on the part of complaining victims? Okay, so as I said, this is a very brief, short section on rape by impersonation or fraud, rape by extortion, or rape of intoxicated persons. I have posted on Twin, as I mentioned at the outset of this recording, a number of supplemental materials you should take a look at. The first is a link to a 60 Minutes story about Brock Turner, and actually, more particularly, a story about Chanel Miller, who was the victim in the case. Actually, I should say is the victim in the case, but for a long time she was known simply as Emily Doe. Her name was not publicized. And it was not until recently where she decided to reveal her name and her identity. So on Twin, there is a link to a story by 60 Minutes regarding Chanel Miller and Brock Turner. You should take a look at that story, read through it. So actually the video is behind a paywall, so I won't ask you to look at the video, but you can read the text online. As well, I have posted a link to a PBS news story on Chanel Miller, so you can hear her in her words talk a little bit about the case. And then finally, this is just purely extra. It is not required supplemental material for you to look at. But at the time of sentencing, Chanel Miller read in court a lengthy victim impact statement. She read it in court before Brock Turner, and she has recorded her reading her victim impact statement. And so that is actually available on 60 Minutes on YouTube. And so I have put a link to that on Twin if you would like to take a look at that. Again, that is not required. My expectation is that you will read the 60 Minutes story related to the link, and that you will look at the PBS video. And then if you want on your own time, if you have the energy or the desire, you can um, listen to or watch her read her victim impact statement. All right, so the last topic in our conversation about sexual assault relates to statutory rape. And again, here we only have a very few number of pages, most particularly because we have already discussed statutory rape early in the semester when we discussed strict liability crimes. So recall here that these are offenses in which the government does not have to prove any mens rea in order to obtain a conviction. So in connection with our discussion at present about sexual assault, you should keep in mind that unlike forcible rape, unlike forcible rape, legal rules regarding statutory rape are relatively uniform and streamlined. All right, so across jurisdictions, you will find quite similar statutory rape provisions. This is in stark contrast to the forcible assault or forcible sexual assault or non-forcible sexual assault variations that we have seen and that we will continue to see in the near future. All right, so in these statutory rape cases, because there's no need to prove um, mens rea, and because they have fairly basic elements as a statutory matter, there is far less discussion about whether or not sufficient force was used or any force was used, about the complexities of the human mind and emotions, about modes and meanings of communication, or about social norms. All right, as we saw in our early discussion of Garnett, the most common statutory rape charge turns on proof of two elements. First, whether a sexually prohibited act occurred, and second, age. And by age, that might refer to the age of one of the parties, usually the victim. So it may be statutory rape to engage in a sexually prohibited act with a person of a very young age, commonly below 13 years of age. The age-based element might also be based on the disparity in age between the parties, as we saw in Garnett. So if there is a 5-year age gap between the defendant and the victim, that might be sufficient to support a statutory rape charge. And sometimes the statutory rape charge based on age combines both the age of the victim as well as the possibility of an age disparity. So, for example, if in some jurisdictions you might see a statutory provision based on the victim being 16 years of age or less and the defendant being 5 years of age, 5 years older, so 21 years or older, or something similar to that. All right, so the most common type of statutory rape charge turns on proof that the sexually prohibited act occurred and some aspect of age, either a victim who is too young or an age disparity between the parties, or both. Another common form of statutory rape, and that was foreshadowed in Garnett, but was not ultimately the issue, is whether a sexually prohibited act occurred and whether the victim was mentally or physically incapacitated or mentally retarded. All right, so here we're looking at a particular type of vulnerable individual. Whether or not the defendant engaged in a prohibited sexual act with someone who was mentally or physically incapacitated or mentally retarded. And then a final form of statutory rape that is quite common, and again, as we saw foreshadowed in Garnett, turns on proof of a prohibited sexual act, and then whether or not the defendant is in a position of authority over the victim, such as a teacher over a student, or whether the victim is in the custody or control of the defendant. So an inmate who is sexually assaulted by or has sexual contact with a corrections officer. All right, so 3 very common forms of statutory rape exist nationwide. Age-based statutory rape based on the mental or physical incapacity of the victim, and then statutory rape based on the defendant having a position of authority over the victim, or the victim being in the custody or control of the defendant. Given that the legal doctrine with respect to statutory rape is relatively uncomplicated, the goal more often is to consider whether statutory rape should be a crime, if at all, and if it should be a crime, when should it be enforced? In fact, some of that was raised in the Garnett case, right? We had a bit of conversation about why the government didn't charge the victim with raping the defendant, who was um, uh, mentally deficient with respect to some of his cognitive abilities, social abilities, and education. Or why didn't the government just not charge anyone? Recall, as we discussed then, and has been a common theme throughout the semester, prosecutors have broad, unchecked discretion to determine whom to prosecute, whom to treat as a victim, and what charges to bring. All right, so if we're looking for examples of the various cases the various statutory approaches to statutory rape, again, Garnett presents the scenario both of an age disparity and also a physically or mentally vulnerable victim. Putting aside that scenario, right, it is quite common to see other scenarios. So, for example, the significantly older adult male and the minor female is a quite common instance of statutory rape. There are far fewer cases involving older women and minor males or boys. If you turn to the next slide, you see in the top left Mary Kay Letourneau, right? And she was involved in a fairly notorious case with her student. She was a teacher in her early 30s and began a sexual relationship with her male 13-year-old student, who's pictured on the slide. She became pregnant by him. Ultimately, she's charged with statutory rape, convicted, and later incarcerated. After she's released, they marry and they go on to have more children. Every year, I hear a little bit of an update about them through the media, and so you might yourself take a look online and see what their status is. So, in these cases in which there is a wide age disparity, such as the significantly older man and minor female, or the significantly older woman and the minor male, right? We can probably agree about criminalization and enforcement. But another very common scenario are those cases where the parties are close in age and maturity and developmental status, and their behavior was consensual, right? So if we think about two teenage kids who are involved in a romantic relationship in high school, and it is sexual, um, should statutory rape provisions be applied to their behavior? So, in Georgia in particular, there have been two notable cases that have come out of the state within the last 10 years, Marcus Dixon and Gennaro Wilson. You can look them up online. Those are pretty well-known cases nationwide. A case that you might be less familiar with and provides an interesting contrast is on your far right, involving Jamie Lynn Spears, sister to Britney Spears, and at the time, her boyfriend Casey Aldridge, who was the father of her baby. At the time she became pregnant, Spears was 16 years old, and Aldridge was either 18 or 19 years old. And depending on the state in where the sexual acts occurred between the two, he could have been charged with either misdemeanor or felony statutory rape. He was not charged, and she went on to bear his child. I don't think they're together any longer, but you can check me on that by looking up online. But he was fortunate. Um, there is another case which did not have such an outcome. And this is a fairly notorious case. arising out of Nebraska. A 14-year-old girl and a 22-year-old male were in a romantic relationship, and she becomes pregnant. With her parents' consent, she and he married in Kansas. They went to Kansas to get married because there was no age limit to marrying in Kansas, and they could not marry in Nebraska, where you had to be 17 years old. After they get married in Kansas, they go back to Nebraska, and he is charged by the government with statutory rape. Marriage is not a defense. He's convicted, sentenced to incarceration. After he's released, they continue their relationship. They have a child or children eventually, but ultimately they do divorce. All right, so it's interesting to think about the contrasting approaches in Jamie Lynn Spears, Casey Aldridge case, and this other case that I mentioned out of Nebraska. So you might want to consider on your own, and let's have a conversation on Twin about why might a legislator vote to decriminalize statutory rape when it occurs between two teenage individuals who are close in age and maturity and developmental understanding. Or why might a prosecutor decline to charge such a case? Or on the other hand, why would we criminalize that behavior? Or why would prosecutors pursue charges in those circumstances? Another question you could think about is whether or not statutory rape should be subject to the same penalties as forcible rape. And so here, when I say statutory rape, and I am talking about the various forms that we've seen, the three particular forms we've seen. Should any or all of those forms of statutory rape be subject to the same quite serious penalties as forcible rape? Is statutory rape as wrong or harmful or dangerous as forcible rape? The last thing you should know is that given the concerns about two minors involved in consensual sexual intercourse, some jurisdictions have enacted what are called Romeo and Juliet laws. That is, jurisdictions have decriminalized or provided for more lenient treatment for consensual sexual conduct between minors who are close in age. All right, in recognition of some of these particular concerns we might have about charging individuals and whether or not we think the behavior should be treated the same as forcible rape. All right, so that's the end of the discussion about these different forms of non-forcible rape, rape by fraud or impersonation, extortion or coercion, um, rape involving intoxicants, or statutory rape. Throughout all of our conversations on rape or sexual assault, a common theme has been evolution of the law from traditional common law to today and into the future. So the last material that you should take a look at for this topic is on Twin. This is supplemental material. It's not in your reading assignment sheet, but I'm asking you to look at it. One is an article by Stephen Schulhofer talking about the reform of rape law, giving some of the background about traditional approaches to rape, talking about Catherine McKinnon and her influence on the movement towards reform of rape, and raising some issues about where rape law might go. So that article is on Twin, and you should download the article and read it. And then the second thing you should do is take a look at a link I have posted on Twin to a video put forth by the American Law Institute about its effort to revise the Model Penal Code's sexual assault provisions. As we know, the Model Penal Code's sexual assault provisions were issued in 1962, and they are quite outmoded by virtually everyone's estimation. And in the last handful of years, the American Law Institute has begun a project to revise the sexual assault provisions. And so this is a very short video that just explains why, or some of the thinking generating this reform. So after you take a look at those materials, let's talk on Twin about where we've been with respect to rape law, where we are now with respect to rape law and where we might go in the future with respect to rape law. And overall, that ends our conversation about rape or sexual assault. As I've said repeatedly in these lectures, I do hope that we can have some interesting and thoughtful conversation on TWIN, not simply about the various doctrine or the elemental approach to the different forms of sexual assault, but also how we think about different factual scenarios. And then as well, how we think about the reformation of rape law, which is really a project of major concern in current times. Thank you. Congratulations for making it to the end of this first week. And I'll be in touch soon with what happens next week.